Good morning, Mr. Corbo.
Good morning, Chief Justice Marshall. Good morning, Associate Justices. My name is James D. Corbo. I represent the juvenile known by this court as Porter P. Assisting me today at council table is Attorney Rachel Scott, who assisted me with the brief. I'm asking this case comes to you from the appeals court reversal of Judge Leslie Harris's allowance of my motion to suppress evidence. This court allowed my motion for further appellate review, and I'm asking the court to affirm Judge Harris's ruling that my client and his mother had a right to privacy in that locked bedroom in the family house shelter.
I'm sorry, go ahead.
What about the fact that your client's mother had agreed to be governed by the master plan that said that the staff could have access to their space?
Your Honor, I asked you to look at Commonwealth versus Nielsen, the Fitchburg State case for
But that was the facts there were very different. The individual in Nielsen could rearrange his furniture in the room. He could have guests in the room whenever he wanted. He could have food in his room. He could have valuables over $100 in his room. It was a totally different situation.
Right,
I don't see it as analogous at all.
Well, this case is a very different situation, and I submit to the court, not only is it a case of first impression for this court, it's a case of first impression for the country. And what the appeals court did was they took this square peg of somebody living long-term in a shelter, and they pushed it through the round hole, applying past precedents which are totally different. And in this case, my client and his mother lived in this shelter in the bedroom. And when they left for the day, as they were required to do, the mother was required to leave to look for housing, she locked that door. And the staff is allowed, the director, as executive director, not as a cohabitant or a co-tenant, is allowed to have staff go in at her direction to make sure they're complying with certain things, which they have to do given that there are 24 rooms and there are 24...
But one of the things they're supposed to do is comply with the laws.
And no gun policy.
No gun.
Right.
So she has permission to go in to make sure that the laws are being followed.
The policy simply says you cannot have a gun in the shelter, you can't have drugs in the shelter, you can't break the law. That does not give... does not mean that my client and his mother waive their constitutional rights by being put into the shelter to the government.
All right, but you don't say, take the police out of this. I mean, would there be any problem if Ms. Brown, that was the name of the director,
Yes,
right?
Ms. Cynthia Brown, yes.
If she hadn't been nervous about the gun, and she had done what she did with drugs. She'd used her key, she'd gone in, she'd searched, she'd found the gun under the duffel bag in the closet herself, and then had given it to the police. Would that be a problem?
No, because there's no
Well,
government
are you
search.
arguing, yes, but then are you arguing that private citizens should have to go in and take a gun, which may be loaded and the safety may be off, and have to hold a gun and have it around other people in the shelter?
No, they don't have to because
But you just said the woman could go in and take the gun. For all you know, the gun would go off when she picked, or she knew the gun would go off when she picked it up.
She did the right thing. She called the police, and Detective McLaughlin had probable cause to apply for a search warrant. And that's what should have happened. She did the right thing. She called the police. She got their assistance. They investigated over several days. And at that point, the law requires them to get the search warrant. And essentially, what the appeals court said was basically that if you're living in this controlled environment, and I want to take away the word homeless, they live in a family health shelter, they meet strict requirements to get into the shelter, but this court's decision, and I ask you to look at the privacy rights in this case, applies to much more than people living in homeless shelters.
Yeah, that's fine.
But why couldn't the police do what Brown herself could have done, where she accompanied them and essentially watched them while they did what she herself could have done?
Well, the difference, Justice Spina, is that she is the law requires consent. Okay, the privacy issue I submit to you is there is an expectation of privacy that's objective. at
Let's
that
assume
point.
let's assume that's the case.
Yeah,
Right.
Let's assume the
That's a
appeals court's
question
wrong.
in this case.
Let's move to this other issue
Let's
of
move to the consent issue.
authority.
Yeah.
Well, then at that point, all the precedent, both in the U.S. Supreme Court, this court, other states, is all the factors look at cohabitants. It's the boyfriend, the wife, the guy sleeping on the couch, is he a cohabitant? There's no other, the only other precedent, if you look at Nielsen, is the administrator of a college, because they have the right to go in and do that. This court said that does not mean that they can simply waive the constitutional rights of somebody living under their care. And
What did the residence manual say?
The manual said that in terms of the weapons, Justice Ireland, or
No, access to the rooms.
right, that because it's a small space, they have to make sure you don't have you're not cooking food in there, it's not messy, that they can let professional staff in, meaning like cleaners or painters, as a landlord could, and that there was controlled access where the director could allow staff in at a certain time, and that there would be room checks where there'd be an announcement.
Not at a certain time, any time,
Any time.
to inspect for health or safety issues or failure
Right.
to comply with the other regulations
Right.
of the house.
For the staff, and balancing that as a privacy issue. If you or I were to go out on the Columbia Road this morning and knock on that shelter, we would not be allowed in. If we asked who lived there, we would be told that there's a
Because
privacy
we have no
policy.
authority to get in, but certainly if we went to the executive director, and she would have authority to enter any of the rooms to
Right, but if
inspect.
we asked her who lives here, she would say, there's a privacy policy. I cannot tell you who lives here. And in balancing, if you look at the manual, there is with the responsibilities, there are rights which help serve to let people become self-sufficient and move on and get housing. And what I'm asking the court to look at is the consent exception focuses on when you choose to live somewhere, whether it be with a friend or a loved one, you assume the risk that you give up privacy when you live with that person, that when the police come to the door and they knock on the door, your roommate will let them in. And that, I think, if you look at the reasoning of all courts, it's an expectation that you assume again with that privacy. And what I'm asking the court to find
Why wouldn't that assumption apply here, where you go to live in a place under rules and regulations that govern what you can have in your room, require personal items to be inventoried, require you to be out of the room from 9 to 3 every day, a whole laundry list of very exceptional terms which really limit your control over your space and really maximize the control in the manager. Isn't that something
Right,
that we should take a look
but the difference, Justice Cordy, is the locked door in the bedroom in terms of, and again, look at Nielsen, is are you going to waive your constitutional rights for the government to come in? And under these facts, my client and his mother were living there for over 7 months at this point. The expected stay was 4 to 6 months. The policy talked about
The brief says 4 to 8.
4 to 8, excuse me. But they were in their 7th month at this point, and
Don't they run the risk that the manager, who has all of this authority and control, including dictating where they will stay in the house, they could be moved from room to room, don't they assume the same kind of risk that that person might consent to a search from outside authorities?
But Ms. Brown in the shelter, they're not cohabitants. They're not living with them in the room in terms of...
I understand that. Well, yeah, but you would have to say that the executive director has much more control over the space than the person who happens to be living there under the restrictions, under the contract.
I take it you are asking us to say, in the Nielsen case, the dormitory case, the student had signed a contract as a
Correct.
condition of being in the dormitory room that permitted not only just the director but staff members to enter the rooms at any time to inspect for precisely the same reasons: health, security, those kinds of things. And in the Fitchburg case, the resident, tutor, whatever it was there. The police were there. They found the drugs, and the court said, no, you can't do that, because what the student did was agree with the university, with the resident, that they could come in, but didn't agree that the police could come in, right?
Correct, Justice Marshall. And if you were not to agree with my argument in my brief, you'd essentially either be reversing that case, or as in the two different amicus brief filed by multiple parties, what you'd be doing is essentially creating two classes where somebody who is told, we can search your room any time in your dorm room, and they hear the sound of a cat, and they're allowed to go in and search your whole dorm room, and you know that.
You have given them the right to invite the police in.
Correct.
And
And the
Nielsen
court in
said-
that case,
It's a different situation. In Nielsen, for instance, the student was paying for it. It's not a different constitutional. It's not applying the Fourth Amendment differently. It's the situation that's different.
Justice
in
Cowell-
Nielsen, the student had a significantly more control over his room. He could move the furniture around in his room. I mean, the fact that these tenants they're not even tenants, but these people in the room could not even move the furniture around in the room significantly limits their freedom in that room.
the difference there, Justice Cowan, and I want to get to the issue of paying money. Are you saying that if that young man had a scholarship that the state paid for him to stay in the room, therefore he doesn't have privacy
No,
versus he
I'm
paid his own
saying,
money?
I am saying that the rights he had in the room were so much more than what these people had in the room.
Right, because-
they couldn't have food in the room. The
Right.
student can have food in his or her room.
Because-
they couldn't have guests in the room. The students have guests in their room. Sometimes they sleep overnight, all
Because
the time.
the reality is that when you're homeless and you qualify for this benefit, there are obviously limited funds. And that we can't pay for you to have your own apartment. That's why you're in a temporary shelter. You have to try to get that on your own. Obviously, a college student expects a little more freedom, and that's why they have the freedom.
What do you say to the, finish your answer.
Just where do you draw the line? Do you say, therefore, you have no privacy rights because we're putting you in an...
You don't have an expectation of privacy, given these circumstances. And you can't keep over $100 of valuables in your room. I mean, the limits are so extreme in this case.
Right.
And I'd like to ask you, because it isn't clear from the brief, can the occupant be ejected by the management?
They can, and there's several. If you violate certain rules, you can be ejected. If you violate the DTA rules in terms of your benefits run out, you can be ejected.
I mean, for a gun, you can be ejected immediately. You're required to be ejected immediately, right, for a gun?
Correct.
Yeah.
But-
What do you say to the apparent authority argument that the Commonwealth makes?
Well, the apparent authority, I think, is basically like the train has left the station. I'm asking you to put the brakes on this in terms of there's really no limit. And I argue a dissent from Justice Thurgood Marshall in Illinois versus Rodriguez, which I'm asking you to look at Article 14 and put some control on the apparent authority. Apparent authority here, Detective McLaughlin spent quite amount of time thinking this through. And Judge Harris, in his findings and in terms of what he said on the record, did not credit that this was reasonable because he had so much time and he made the wrong decision, in my opinion, in Judge Harris's decision. And what he could have done was gotten the warrant. And what I cross-examined him, and it's clear on the record, I put it in my brief, of what he said was, we really weren't looking for consent. You know, I really didn't want to inconvenience the families. I'd have to lock the place down, and we wanted to do this quietly, and I wanted to give your client a chance to be summoned in and not arrest. And he went forward. And Justice Marshall says that if you do that...
I believe he said, I thought I was helping her.
Right.
I thought my job was simply to aid her in getting that gun
Yeah,
out
but
of the room.
that I think, Justice Gantz, is his way of, you know, sort of saying that, well, I'm not really the state actor here. I'm really helping her do a private search. And clearly it's a government search. And once he gets to that point, it becomes a government search and the Fourth Amendment applies.
But is there some inherent contradiction in your beginning your argument by saying this is a matter of first impression, not only for this court, but for any court, and saying it was sufficiently crystal clear to that detective that he was not entitled to enter, that it was not reasonable for him to believe he could?
No, because Justice Marshall in his dissent suggests that if you make the wrong decision, you have to live with that. And there really is no precedent for him to look at in this case. So,
But every apparent authority is a wrong decision. You believe that this person had the ability to consent, and in fact they didn't. It was the girlfriend of Rodriguez. She wasn't living there. They reasonably thought she did. They reasonably thought when she said, "Come on in,"
but
she
the
had
difference
the authority. They're
is,
wrong.
But the difference in this case is that, you know, let's go back to the Fitchburg case. If the school police said, which this issue wasn't raised, we thought the school, say it happened today, we thought the school had the authority, and they all say, well, none of us read the Nielsen case. I'm sorry I didn't know that. Certainly the court I suggest the court would not allow that to happen. And essentially, in this case, because she was an executive director, not a co-tenant, as all the other cases are, that he made the wrong decision at some points. The exception's going to, take over the rule if we allow this in the future. And I asked you to sort of look at this and see what would have happened to Nielsen had that issue been raised, which it wasn't raised.
Did Brown have an FID card?
She did not. I don't believe she did. That wasn't
Does
brought up.
that make a difference in this case?
Did Brown have an FID card?
Yeah.
You mean the
To get
executive
the gun?
director?
Just
To get the gun?
I suggest that even under exigent circumstances, she could take that gun and bring it to the police, and she wouldn't be at risk. But of criminal prosecution, if she would have called 911 right away and say that. But that wasn't addressed in the case.
Thank you, Mr. Corbett.
Thank you.
Ms. Celio?
Good morning, Your Honors. May it please the Court. Kathleen Celio on behalf of the Commonwealth. I ask this Court to reverse the motion judge's allowance of the defendant's motion to suppress. Regarding the issue of consent in Nielsen, because Nielsen is a consent case, what makes this different is that Brown was the only person that could allow the police into this room. The defendant couldn't allow anybody into the room. It was only the director or the staff that could allow the police or anybody else into the room. And I think that, shows her control, her joint authority on that issue. I mean, she was the only person, as opposed to the student in the dorm. The rules were set up such that the staff or the director, who had a common and master key, were the only people that could allow anybody else.
Is it your position that the juvenile had no reasonable expectation of privacy in that room?
Yes, I was just addressing the consent, which is a different.
But move to that. Is
Yes.
your view, which means that the police could at any time just go into that room and search him, and he would have no ability to say that's wrong.
That is correct. This is based on the manual and the rules and regulations that were set up in this shelter.
Okay, but if you're right, the consent is irrelevant because it wasn't even a search because he has no reasonable expectation of privacy.
No, that is correct. My brother has been relying on Nielsen, and I wanted Nielsen's a consent case. I wanted to just distinguish
my question is a
Nielsen.
little bit different. Are you going so far as to say that the police can enter this shelter and search that room without anyone's consent, and
No.
that there's no ability to move to suppress in the absence of probable cause?
Yes, with the fact that they were allowed in by the director.
No.
It's not that issue. If there's no reasonable expectation of privacy, it's no different from leaving your garbage outside for the police to rummage through. It's not a search. Are you saying that this is not a search?
Yes, I am, Your
Which
Honor.
means the police could at any point in time come in, search that room, and this juvenile would not be able to move to suppress at all, even if there was no warrant and no probable cause.
Yes, in these circumstances, because
Even if the director didn't open the door for them?
well, then
Are you saying that the police could come in, suppose, I think Justice Gantz is asking you about a different case, nothing like this case. Suppose Ms. Brown knew nothing about a gun, didn't call the police, but the police just walked in off the street and
The
went in to
police thought
search
there
the
was a
room.
gun there. The police thought there was a gun there, so they
Yeah.
walked in.
But Ms.
and
Brown had nothing to do with it. The director didn't
She
call.
didn't
know
let
anything.
them in.
Well, that's what I was starting with. The director actually allowing them into the homeless to
No,
the
but
shelter.
Justice
No,
Gantz is
no.
asking you a different question. He is taking Ms. Brown, the director, out of the picture and asking you if, without her, forget about this case, can the police just come into the room and search it for a gun because they think there's a gun there?
Yes, because she says there's no expectation of privacy, so it's not a search.
Based on the resident, but maybe based on the agency, Brown would have a privacy interest if she was charged with the gun.
No, she's not charged with it.
Make believe Brown got hit by a car and she was killed before this happened, okay? And the police thought that this kid had a gun in his room.
Yes.
They also think, hey, we've seen the rules and regulations here. This kid has no reasonable expectation of privacy. They kick the door in. Is that a valid search?
It would not be a constitutional search because the defendant doesn't have an expectation of privacy in room 24.
And that's because of the residence manual. That's your position.
That is correct. That a shelter.
It would not be a
constitutional
constitutional search?
It wouldn't be.
Because
It wouldn't be a search because if you don't have a privacy interest, then there's no
No,
search.
she said it would not be a constitutional search. But you
No,
had
what she
two
means is
negatives.
it doesn't qualify as a search in the constitutional term, in sense of the word.
because he has no expectation of privacy.
Correct.
And that's because of the residence manual.
Correct.
And what in the residence manual says they have no expectation of privacy?
Well, if you look at the factors that this court looks at in looking at a privacy interest, I think is control and access. And this individual does not have the ability to exclude other people, could not invite in people, could not invite in guests, could not invite in other residents.
But you don't think that living there for 8 months as your only home gives you some expectation of privacy, even despite the manual?
I think I think you can't look at it without the manual.
There are lots of situations where the condition of living somewhere is very tightly controlled. Many colleges say you cannot have guests in your room. Many colleges say you cannot have alcohol in your room. Many colleges say you cannot bring food into your room. Many colleges, or other situations, boarding houses, or even in some, not hotel rooms, but rooms that are used for conferences. There's a whole level of restriction. Are you saying that in all of those cases there's no expectation of privacy?
I think it depends. I think it depends on the facts and the amount of access and control that the individual is given.
Let's just take a case where the policy is you can have no guests in your room. There's a common room downstairs on the ground floor, and that's where guests to the dormitory come. You cannot have guests in your room. No expectation of privacy in that college dorm?
And you pay for the? This is what I'm looking at. And you pay for the dorm?
You may be on a scholarship. You may not pay for the dorm. So you've got a different rule for people who pay versus the people who are on government aid.
I think in that case you may have a privacy interest, but in this case, not only could he not allow anybody in,
So we have to determine you can't have a guest and you can't have alcohol or drugs.
And I mean,
no privacy?
I think that, would you have a provision that allows the staff who has a common key to enter and search?
Yes, we've all signed that contract, because that's how we know we can't have guests, we can't have alcohol. We've all signed that contract. Every student has signed that contract. Some students pay for it out of their own pocket, some students have their parents pay, some students have the state pay.
And no one else is allowed in the house? I think then you would get closer to the situation we have here, where
why does that not leave me with an expectation of privacy? For example, in my personal letters, my capacity to be researched.
Because if you're looking at the place and the shelter here, obviously has.
Aren't you just easier dealing with consent?
It is, and I started with that. But I don't think I think that the shelter here, there's a safety concern, and that
there was a safety concern in Nielsen. There's a safety concern in dormitories. Believe me.
I understand
You're dealing with juveniles in dormitories, and they do really crazy things when they leave home for the first time. Really crazy things.
No, and
probably more crazy than homeless people.
I understand, Your Honor,
and
but
I'm not indicting everybody under the age of 21 in the United States of America, but they do some crazy things.
No, I understand, Your Honor, but if you look at the cases that are set in the briefs regarding the dorms, and if you look at Nielsen, the limited information is that they sign a contract saying that an RA can come in, and that's it. There's not a situation presented regarding the dorms in which everything is so regulated. All of the dorm cases involved, they were looking for pot, that an RA came in and looked for it based on they can come in and look for hazards and such, and then the police are called. It doesn't, none of those cases, and if you even look at the rationale of it, they talk about how this is the same tendency as someone living in an apartment, that they have all the freedom still of living in an apartment across the street, that they have they pay for the residence. It's very much looking at this is the same occupancy as someone being across the street living in an apartment. And I
say that's not here in this case, because They don't have control.
Yes.
That's what it boils down to.
Yeah, and it would be a different situation, a different set of facts if a college dorm, because of the violence that has been prevalent, on college campuses, would set up dorms with regulations and rules that were similar to here.
Are you saying people in shelters who don't have control have no privacy rights?
I'm saying that a shelter could set up. A shelter could set up rules or lack thereof rules that afford individuals what would be a reasonable expectation of privacy under
Why
the
does the
Constitution.
government get the benefit of how a private shelter wants to run?
Well, because I think that if you look at in the situation, it's a shelter that is concerned about.
Let me
the
go back
safety.
to Justice Gantz's question.
Yeah.
If there's garbage on the street, right, you take it out, you put it on the street. The police can certainly go through it, right? No privacy, you agree?
Anybody can go through it. Yeah.
Exactly. Anybody can go through it. Are you saying that in this dorm, anybody could go through and search?
No, because there's the front door, which
No, anybody who happens to be in there. A cleaner, it gets cleaned, can go through and search and read the letters and look to see who's telephoned and try on the dresses and the coat that's hanging in the closet, because you can do that if it's garbage.
Well, what I would have to say is that anybody, Ms. Brown or other staff were the only people that could allow in the cleaning person.
No, but the cleaning person goes in for a specific purpose. The cleaning person may be sent to take, move the garbage from my side of the street to the other side of the street. But in so doing, if I've got no expectation of privacy, the cleaning person can open it, read the letters. If there's a thrown away scarf or a coat or something like that, pair of old sneakers, can take those. Because there's no expectation of privacy.
No, but there is an abandonment issue that wouldn't be true in the room.
Isn't your better position that the director had the position, was in a position to give consent?
That is true, because it's directly in the manual was that the director was the only person that could allow
And then you
people
run
in.
up against Nielsen, right? And then you're trying to explain why, because the Nielsen, the director, the resident authority could go in to search. And you explain Nielsen as not, isn't that why you want to push the privacy argument so hard?
No, because in Nielsen, the RA couldn't allow the police to enter. Only the resident could allow the police to enter. In my situation, the resident couldn't allow the police to enter because they couldn't allow anybody to enter. Only Cynthia Brown could allow the police to enter or anybody else in. I guess
in this situation, could the resident allow anybody else to enter in the room?
No. That is very clear. No guests. The only ways it can come up is the people that Brown could let in, the guests. You could actually have guests, but they only could be in common rooms, or that other residents who, it's marked throughout the manual, could not enter anybody else's room. So it was only Brown or other staff who had the master key could allow anybody in. And if your honors have no further questions, the Commonwealth will rely on its brief.
Thank you, Ms. Celia.
Thank you.